In landlord-tenant law, a tenant in certain circumstances may be entitled to a rent abatement, that is, a stoppage or reduction in rental payments. But what if a landlord fails to perform covenants that induced a tenant into entering the lease? May the tenant be entitled to a rent abatement? In Richard Barton Enterprises v. Tsern, the Utah Supreme Court considered this question. In November of 1991, Richard Barton Enterprises leased the first 2 floors of a commercial building in Salt Lake City from John Tsern to establish an antiques dealership. Under the 1-year lease, Barton agreed to pay $3,000 a month in rent. Barton also paid $3,000 as earnest money for an option to purchase the building. In addition, Barton accepted the building in as-is condition. However, Tsern was required to repair the building's leaky roof and restore a freight elevator to working order. Over a period of several months, Tsern made limited repairs to the elevator. In fact, the elevator didn't operate at all during certain periods of the tenancy. When a city inspector shut down the elevator for safety reasons, Tsern refused to pay to fix it. Barton and Tsern discussed rent abatement due to the elevator, but never came to a mutual agreement. Further, Barton paid less than the full rent for January and February, and Tsern cashed the checks but maintained he was entitled to the full amount. Subsequently, Barton sued Tsern in state district court for a declaratory judgment to establish Tsern's legal duty to repair the elevator. In response, Tsern counterclaimed with a demand for full payment of rent or eviction. While the suit was pending, Barton gave notice that he was exercising his option to purchase the building. The court then ruled that Barton could exercise his option to purchase the building prior to the conclusion of his claim. Following a bench trial, the court ruled for Barton and entered judgment against Tsern for the cost of repairing the elevator. The court also found that Barton was entitled to a rent abatement of $2,000 per month, which could be deducted from the purchase price, plus attorney's fees. Both parties appealed to the Utah Supreme Court.